28 years after the Good Friday Agreement, we still have not reached a resolution on how we deal with the past.
Hello and welcome to the Justice Edit from Irish Rule of Law International. I'm your host, Evelyn McClafferty. In this episode, human rights lawyer Darragh Mackin reflects on Northern Ireland's unfinished business, how a society emerging from conflict continues to grapple with the legacy of the Troubles.
To allow reconciliation to happen, we can't just simply put a plaster over the previous cracks. We must address them.
Darragh is a director at Phoenix Law in Belfast, and in this episode he discusses some of the most significant cases he's been involved in, including his role in the long campaign for justice after the Stardust fire in Dublin in 1981, in which 48 people were killed.
I remember one thing vividly. When the verdict was read out, the whole room just erupted. And throughout all the noise, it was as if the noise just stopped, and I just heard one lady to the right of me say two words: "At last."
Darragh also reflects on the current fragility of the rule of law globally and what's at stake if it's undermined.
And I think that if we effectively disregard the rule of law, we will enter a very, very dangerous place, because then we're entering in a world where there is no rules.
We're delighted to have Darragh Mackin with us in this episode. He begins by reflecting on how his childhood shaped his decision to pursue law and fight for justice.
I grew up a place just outside Newry originally. I went to school in Clough-Ray. And when I was growing up, unfortunately, it was still quite normal where soldiers, etc., would have walked down the streets. The helicopters would have passed overhead. So from a very early time in my life, I still remember the remnants of the conflict and the Troubles here from early on. Whilst I came from a family of teachers, I had a big influence from my grandfather, who was a bit of a campaigner for children's rights and was very, very influential in promoting and pushing on like our local GA club and youth clubs. So that was obviously passed on to my father, who was always a very, very, very focused on community and the importance of being involved in the community. And it's kind of that backdrop that obviously probably shapes who and what I ultimately wanted to become. So as a lawyer, I always thought that it's very, very important to make a difference, to be part of the community. I have to say I've been very, very lucky because in the kind of area of work that I do, you can actually, one, be involved directly with the community in many, many different ways, and different communities, to be fair as well. And secondly, sometimes you can make a difference through the various work. So probably has played a much bigger part than I appreciate until you ask me on the kind of area of law that I now do.
So you're talking about that making a difference piece, and a lot of your work has focused on structural human rights reform. Looking back to the pre-Good Friday Agreement period in Northern Ireland, how different were the possibilities for lawyers who wanted to pursue that kind of impact? What was realistically achievable within the legal system then compared to today?
Well, unfortunately, the backdrop to lawyers during the Troubles and the conflict here is quite a depressing one. Many people will know Pat Finucane, who was murdered for being a human rights lawyer, and latterly Rosemary Nelson, who was also murdered as a result of being a human rights lawyer. And unfortunately, that gives a very, very depressing backdrop to what law looked like back then, where many people, once they became many people, for unfortunately very, very sinister reasons, were aligned with their clients and targets put on their head simply for doing their job. And unfortunately, whilst that thankfully is a part of the past, the kind of campaign by which lawyers are targeted for who they represent continues. And I think it's certainly an important piece of work that needs to be and continues to be of fundamental importance to lawyers across the world, because it's important for the rule of law to exist, that lawyers are not connected with their clients, that we're seen as professionals. We have a job to do. And if lawyers become under threat or devalued or undermined because of who they act for, then the rule of law is undermined, the rule of law is devalued, because the rule of law must operate in a prism that is applies equally to everybody. But we're very, very lucky in my view, in one sense, and maybe it's the optimist in me, but when you look at the very depressing backdrop, it has given rise to a very, very inspirational journey for human rights in the North. And what I mean by that is when we look at, for example, the various cases and jurisprudence that arises in the European Court of Human Rights, we see a massive influence coming from this jurisdiction. And I think the late Lord Kerr used to always say, this jurisdiction punches way above its weight. And I think that's never been truer than in the human rights field, because unfortunately, due to our very, very depressing backdrop, we have had reason to litigate for very many years, and that litigation has not just been domestically, but has gone the whole way to the European Court. And for those reasons, we see issues arising out of Northern Ireland appearing and featuring extensively through the European Court jurisprudence. And I have to say, there's been some seminal lawyers who have emanated from this jurisdiction, who made their name being involved at the coal face during the Troubles. We mentioned the late Lord Kerr, who was obviously one of the greatest lawyers ever to rise from this jurisdiction. Another one that often goes unmentioned because of his predominantly academic background, but who continues to be a massive hero of mine, was Kevin Boyle, who maybe I'm biased because he originally arose from Newry as well, but went on obviously to become one of the lawyers who took many cases to the European Court of Human Rights. Latterly appeared for victims of the Turkish conflict, and obviously now was one of the patrons of the NUI Human Rights School in Galway, and obviously founded the Human Rights Institute in Essex as well. So I think it's really, really important that we've seen a lawyer, who, coming from this jurisdiction has gone so far, and I think that his work is certainly resonates with me on a daily basis. I think he was an incredible lawyer. So it's a broad spectrum of people who, unfortunately, maybe through the very, very depressing antidotes of the conflict, have produced some very, very, very important academic and legal work. And maybe that's the positive that we can take from such a depressing backdrop.
Juxtaposing that with the situation that you're currently in now, do you feel that the landscape has changed?
I think the landscape has thankfully changed. I think that we're very lucky to live in the society we now live in comparison to what lawyers had to face back then. Unfortunately, there remains challenges. The challenges may still exist in some shape or form, and maybe not of the same gravity, but they arise in a different way. For example, with the rise of social media, lawyers continue to be attacked and targeted in line with their clients. Um, in addition, whilst there were many cases taken to the European Court of Human Rights to try and get justice for victims of the conflict back then, uh, as a result of the political impasse and the inability to reach a resolution on how we deal with the past, that continues to be the case. And it's probably a depressing fact that, 28 years after the Good Friday Agreement, we still have not reached a resolution on how we deal with the past. And as many will know, the last Tory government tried to bring in legislation, successfully brought in legislation that sought to draw a line in the past and give immunity for perpetrators. Now, that has been the subject of a challenge that went the whole way to the Supreme Court, and indeed has gone the whole way to the European Court of Human Rights by virtue of an interstate case from Ireland versus the UK. So when we look back at the what history tells us in terms of human rights in this jurisdiction, we see that 1976, Ireland took the first interstate case against the UK. It remains one of the most cited cases in human rights jurisprudence. And here we are in 2026, and Ireland yet again are forced to go to the European Court of Human Rights to protect and uphold the human rights of citizens in this jurisdiction. So whilst we have made massive progress, I think there remain challenges. The challenges may just look differently than they did back then, but unfortunately they still arise.
You're talking about the European Court and you're talking about the immunity case, and I'd love for us to go into further detail on that a little bit later in the conversation. But you're right, public confidence in politics in Northern Ireland has risen and fallen sharply since '98, with long periods of paralysis at Stormont. In contrast, how do you think the justice system and the principles of the rule of law have functioned in the post-agreement era? Has law provided a level of maybe stability that politics hasn't?
I think it undoubtedly has, and Anybody who knows anything about the North will know that we very rarely agree on everything, and unfortunately, it's a very imperfect model to fix a very imperfect situation. And we often forget that in reality, we must take a step back and realize that the North is a society transitioning from conflict, and that comes with its own challenges. Some of those challenges are often unnoticed; they become part of the DNA of the society itself. And in addition, we have seen through the power sharing model what should be very basic rights issues becoming very sensitive and difficult political issues. And when that arises, we have seen the significance and importance of the courts, the judiciary, and the rule of law. And what I mean by that is, let's take a couple of basic examples. We have seen issues such as same sex marriage, abortion rights, right to legacy pensions. They're just three very simple but very important rights based issues. But unfortunately, due to political disagreement, they became stuck in the mud, and they resulted in a significant impasse and a significant delay in victims and citizens getting access to very basic rights. And when that political impasse arises, we've seen the role of the court step in. And for us, and for me in particular, I think it has demonstrated the importance of the rule of law, because the rule of law applies equally to everybody. It applies objectively, and that's where our independent judiciary, in my view, has led by example in showing that when issues become difficult by means of politics, the separation of powers demonstrates that the politics and the noise must be put to one side, and we must deal with what the law requires. And we've seen developments and evolution in those three areas, which, to be frank, are very simple, basic rights protection questions, but have become very difficult, thorny issues in this jurisdiction. But thankfully, through the rule of law, we've seen evolution, we've seen development. And I hate to say it, had we not had an independent judiciary, had we not had an independent rule of law, we simply wouldn't have seen progress in any of those three issues. So I think, what again, maybe look at the optimistic aspect of the negative problem. I think the negative problem is, the power sharing system is far from perfect, but the optimistic and the bright side to things are that it maybe has shown the importance of the rule of law in a much greater scale than ordinarily would be seen in a, dare I say, a functioning democracy.
Given that, then what pieces of legislation or legal developments? I mean, you've talked about abortion there, and you've talked about various other legal issues, but what for you have been the kind of the most advanced pieces that have resulted in the upholding of human rights in their totality in Northern Ireland since 1998?
Well, I think there are many examples what we can point to which have shown the importance of the courts. I have to say, for me personally, the one that stands out, and I'm biased, of course, due to my own involvement, but it is the abortion rights campaign. Women were trying to seek access to basic services. They met an impasse due to the political stalemate. It became a very difficult issue politically to resolve, and showed over many years that it simply couldn't be resolved by virtue of politics. And that despite different efforts at different times by different aspects of the political institutions, there was no progress being made on remedying the problem. This ultimately resulted in the landmark proceedings that ultimately went the whole way to the Supreme Court. And I had the privilege of acting on behalf of one of the women, Sarah Ewart, and Amnesty International, and Grania Taggart, who ultimately led the way in showing the importance of looking at this issue through the lens of the rule of law, looking at it through the lens of human rights, not looking at it through the lens of the politics and the difficulties that we see in this jurisdiction. And the depressing aspect of it is we look back and we see, well, in the South, it was resolved very quickly, obviously by means of a referendum. We've seen progress being made in England and Wales, but yet through the virtue of the devolution and the political stalemate on this issue, there's no progress being made. And anybody who's ever read the Supreme Court judgment, or indeed the latter decision by the now Chief Justice in the Sarah Ewart proceedings that came second, it became clear that these were women who were suffering in the very cold face, who were just simply asking for basic healthcare protections. And the real irony of the situation is, if they jumped on a plane and went to England, they could access them, or they crossed the border less than 40 minutes away, they could get access to the same services. But yet, in their own jurisdiction, surrounded by their own family and friends. They were being they were given a vacuum of rights, and that was a major problem. And for me, it was a real classic example of where the court stepped in, and the Supreme Court judgment makes for great reading because it sets out in clear terms. Look, let's look at what these women have suffered, and let's look at what can be done. And whilst they didn't in that decision quash the law, what they did, or given or make an order of or declaration of incompatibility, they made it in clear terms that the Secretary of State now need to reconsider the position and to take the unique step of resolving the problem directly from Westminster. And that's ultimately what happened. And I think that is a really simple example of fundamental change, landmark change in my view. Women can now get access to abortion services at home. The law was brought in, which brought our law into line with the CEDAW recommendations, which is the international approved standard. And we are lucky now that the law has been amended to ensure that women can access the services in the North.
Darragh, you've been consistently critical of the British government when you believe its actions undermine human rights and the rule of law, particularly on legacy and accountability, and you've touched upon it. One of your most recent challenges is the conditional immunity provisions in the original Troubles Act, which have since been removed. Can you talk us through that case and what was at stake?
Yeah, I have to say, I don't make those criticisms lightly, but when you implement legislation that seeks to bring in immunity and amnesties for perpetrators of the most horrendous crimes, murder, attempted murder, rape, etc., and in a situation in which it was ultimately imposed upon the citizens of this jurisdiction, as I said earlier, anybody who knows anything about Northern Ireland knows that we very rarely agree on everything. And when we agree on everything, the alarm bells must go off, because on the issue of the Legacy Act, it was a unanimous agreement across every political spectrum. There was unanimous agreement that that act should not have been brought into force. Everybody disagreed with it. And yet, despite the protest, the British government took the decision to unanimously bring in those provisions which sought to bring an end to all aspects of legacy investigations. And when we look back at the significance of legacy investigations, we must look at it through the lens of how significant they have been for people of this jurisdiction. We've seen many people who were, for example, criminalised as a result of false or inaccurate or misleading or collusive investigations many, many years ago. And as a result, false and fake narratives were created. And there's many examples of that. We can look at the Bloody Sunday victims. We can look at the Ballymurphy victims who were wrongly criminalised as a result of ineffective, to put it at its lowest, investigations many, many years ago. But then through the use of litigation and through the use of fresh inquest and a fresh inquiry, those people were exonerated and found that they were unarmed civilians who were unjustifiably killed. Now, if we look at that through that lens, had there not been fresh investigations, those people, those families would still be in a position where their loved ones would be criminalised without any evidence whatsoever. Without any evidence whatsoever. We look at another example, Darragh Mackin, who was shot in the back by a British soldier walking through a checkpoint. No prosecution. But because of litigation many, many years later, he was prosecuted, he was found guilty, his appeal was dismissed. That's the significance of being able to fix the wrongs, even many, many years later. And a criticism that many people make of this jurisdiction is that, we're always looking back. But as the famous quote goes, a silly person keeps one eye on the past, but two eyes looking forward. And the term reconciliation is often bandied about, and it continues to be bandied about even through this Legacy Act. But the simple starting point for reconciliation is, how can you reconcile if you don't know what has happened before? How do you reconcile for something you don't know what you're saying sorry for? So to allow reconciliation to happen, we can't just simply put a plaster over the previous cracks. We must address them. Because only when those previous wrongs are corrected can the society itself move on. And we've seen a number of examples of where that has effectively happened. And I don't sit for 1 second and say that the system that we had prior to the Legacy Act was perfect. It was by no means perfect, but it worked. It worked in some degree. Whereas what the British government intended to do and did succeed in doing originally was to bring in an act to operate as a guillotine, to cut away all of the previous legacy investigations, to bring away with litigation, to bring away with fresh inquests, to bring away with prosecutions. And the reality is, it was all driven by one main objective, and that objective was to protect British soldiers. That is an undisputed fact that the High Court judge made reference to, and latterly was included in the Court of Appeal decision. So the motivations were clear for all to see. It was hiding in plain sight that the purpose of that act was to protect British soldiers. And again, I don't mix my words when I say it. They are not an honest broker in that position, because they are seeking to bring in legislation to protect one aspect, and unfortunately, one aspect who were directly involved in many of the conflict-related issues that we've talked about already. So I say it, and I'll say it again. I don't mix my words in respect of the criticism that we brought upon them, because it was criticism that was not only well deserved, but it was criticism that was justified. And when we then look at what had to happen after that, again, families who were put through the mill previously as part of legacy investigations, Martina Dillon, whose husband was killed when he was working as a doorman outside a nightclub, was forced to go back to court simply to ask that or simply to argue that the Legacy Act was unlawful, because her inquest that was part heard, it was opened, was closed without any further notice. The inquest ended, the guillotine came down, and that woman was left in a state of disarray, where she would effectively was on the journey to getting the truth, was on the journey to getting some form of justice, and the guillotine came down in the form of the Legacy Act, and the inquest was brought to a halt. So it's people like Martina Dillon who were forced to go back to court to try and get their rights upheld. And thankfully, we're very, very lucky insofar as the High Court found, latterly upheld by the Court of Appeal, who went further, that aspects of the Legacy Act were unlawful. And they took the unique step in this jurisdiction of setting aside the various provisions, which included the immunity for perpetrators. So thankfully, we've seen fundamental change in respect to that Legacy Act, as directly arising from litigation that again started in this very jurisdiction. Then obviously went the whole way to the Supreme Court, and we currently wait the decision.
You also represented, Darragh, the Hooded Men, one of the most notorious human rights cases of the Troubles. Decades after the original European Court judgment, you helped lead efforts to have it revisited. What did that case mean to you, and what were you ultimately trying to achieve?
When I first met the Hooded Men, as anybody who knows the background of the Hooded Men will know that many years ago, Ireland took the case to the European Court of Human Rights, and the techniques were discussed. And the techniques included the 5 techniques that were deployed on the 14 Hooded Men, which was they were hooded, they were made stand against a wall, they were subject to a very loud, what's called white noise, like a hissing noise. They were deprived of food, and they were deprived of sleep. And when those 5 techniques were put on any man or woman for a prolonged period of time, it had the effect of effectively disorientating you, and it had long-lasting mental impact on you. And the reality is that at the time, the European Commission first found that those techniques were torturous, and the European Court of Human Rights latterly found that they were inhumane and degrading treatment. And this is where language is important. Those men, when I first met them, continued to carry the can of a deep sense of injustice by the virtue of the fact that the European Court had not used the word torture, had not gone on to say it was torturous. And that they for almost 4 decades later, they continued to hold a great sense of injustice about this, the impact that this had. And when fresh evidence came to light through research done by the Pat Finucane Centre and RTE and NUI Galway, it became clear that what the British government were effectively telling the European Court in 1976, i.e. that the techniques didn't have long-lasting impact, and that it was conditioned by a number of effectively soldiers and IUC officers, was in direct contravention to what the actual evidence showed. At the very same time, firstly, it became clear that the highest echelons of the British government were involved, which included the Prime Minister. The notes became clear that they knew fine well what they were sanctioning, and indeed used the word in the memos, torture. They knew that they were sanctioning torture. And in one instance, it actually became clear that some of the British ministers involved actually watched a demonstration of the techniques before they were deployed. And then we seen that the medical treatment at the time when the Hooded Men were released, they were examined by doctors from the British government side who were advising the government that they were very lucky in one instance that the man who he was examining did not die, that the techniques had long-lasting impacts and they would continue to have long-lasting impacts for the rest of their lives. Yet at the same time, the British government were telling the European Court an entirely different story. So we applied to reopen the case, on the basis that the court got it wrong in the first instance, that the correct approach was that the court should acknowledge and find that it was torture. Now, regrettably, the European Court of Human Rights didn't take the opportunity to correct the narrative insofar as they found that just too much time had passed to be sure as to what the court had in its mind in the first instance. It is worth noting that at that time, the then Irish judge, Schieffer O'Leary, dissented from the approach of the court. And it is worth noting that, obviously, as many people will know, Judge O'Leary went on to be the president of the European Court many years later, and still says she dare say she got it right and the others got it wrong. Because the most interesting point of all is that the deputy president of the Supreme Court, who went on to be the Supreme Court president at the time, or years later, Lord Reid, sat as the ad hoc British judge who found that it wasn't torture. Many years later, when the case went to the Supreme Court in London, the Supreme Court commented that the techniques properly characterised today would constitute torture, and indeed that reflected and upheld the findings of the High Court and the Court of Appeal. So there is a kind of perverse upside to this, where we originally were disappointed by the European Court of Human Rights, only to have our faith reinstated in the justice system by the British Supreme Court many years later, who found that the techniques properly characterised today would be characterised as torture, which for the hooded men was a life changing decision, because it corrected the wrong of all those years where people said it wasn't torture, it was inhumane.
What was the reaction?
Um, it's difficult to put into words the significance that that has on anybody, and it's particularly difficult to do when you reflect on the fact that these are men who carried it for 4 decades. But one example, or one story I will tell to give kind of some context to it, is one of the hooded men, Joe Clark, became found out that he was terminally ill, and he had very very short time to live. This was many years. This is about 2 years after the Supreme Court judgment, and up until this time, we had pursued an apology. We'd asked that they apologise. That's all we wanted. We wanted an apology to reflect the fact that these men were tortured. And up until the weeks before Joe passed away, um, he called me one Saturday morning and asked me to come and see him. And I went and seen him, and he said, "Before I die, will you do one thing? Will you see if we can get this apology? It's all I want." And to fast forward the story, it resulted in a number of weeks back and forward in intense negotiations. And I still never forget the day that we got the phone call to say that the decision had been taken by the chief constable to issue an apology. And time was of the essence. And we collected the apology, which was hand signed, and we brought it to Joe Clark's house. And at that time, Joe had not regained consciousness in about 2 days, 48 hours probably before he had lost consciousness. And his wife still has this video, and many people wouldn't believe this story unless it was caught in camera. The apology was brought to him literally on his deathbed, and it was put on his chest. And Joe woke up and said, "Brilliant, brilliant," and that was it. Never spoke again. And that gives to me still makes me. It's actually very difficult to tell that story. Joe was an incredible person, incredible friend, and it's still, to be honest, is an unbelievable story for me, because it's a really good example. Unfortunately, not that many where you can actually hopefully make a difference, but also you can actually see in real life that this is how important issues like these issues are to people who are directly affected. They are part of day and daily life. And I think that it's unfortunately a problem of litigation and cases in general, where as lawyers we all become sometimes a wee bit cold to the fact that names of cases are real people. The impact that the papers that we read, the impact is real life. It's not just some fantasy paper that we're reading. It's real life, and it has a real impact. And I think that that's the most important thing about this job. We always need to remind ourselves about humanity. We always need to remind ourselves about the real human impact that we're having. And I think that we all as lawyers can make a difference. And sometimes the smallest change can make the biggest difference. Like I have to say, one when I'm talking about issues like this, the one change I always think is so important is the introduction of pen portraits to inquests, which is the decision to hear from the victim's family before you hear any evidence. I think that's such an important change, because In the Stardust inquest, when we did that.
Let's talk about that, Dara. Yeah, let's talk about it, the Stardust inquest. I mean, maybe you can remind listeners about that case. I mean, your role was central in that, in the fresh inquest in Dublin concluded in 2024. So, can you remind listeners of the case, the long fight for justice, and explain what drew you personally into that case, Dara? I read that you spent weeks in a hotel working from your hotel on this case, and you became very close to the families indeed.
Obviously, anybody who knows the Stardust will know that, in 1981, 48 young people were killed in a tragic fire in the north side of Dublin. And at the time, an inquiry found that it was likely caused by arson. And for years, the families campaigned that this wasn't right, and it added a degree of criminalising their deceased relatives, their deceased friends, and they've for 4 decades fought for truth and justice and for a proper mechanism to investigate the circumstances. And whilst there were some cracks in the wall that imposed or impeded justice over the years, for example, in 2009 there was a breakthrough in that the government agreed to remove the word arson from the report, but there was no fresh investigation. There was no outcome that the families could justifiably say produced the truth and justice, and they could walk free from the problem. And they continued for years to campaign. And I was lucky then in around 2018, I was approached by families to ask would I consider advising on the prospect of a fresh inquiry. And we give the advice at the time that um, it is possible to have a fresh investigation. We advise that should be done by an inquest, similar to the mechanisms that were used in the north that we talked about. And we ultimately made an application for a fresh inquest that was granted, and that was the start of a journey for those families who then uh, wanted to investigate all the circumstances of the deaths. And I have to say, it's to the credit of the senior coroner, Myra Cullinan, who for a number of years managed an inquest that of the size that had never been seen in the south of Ireland, and managed it the whole way to a hearing where hundreds of witnesses would give evidence before a jury that would have to sit for almost a year. And throughout that process, took really, really courageous decisions, such as the one I mentioned about the idea of having pen portraits. And the reason I think mentioning pen portraits is important is because when the case started during the preparation hearings, we advanced this idea of having pen portraits, because pen portraits meant that before any evidence was heard, the families would speak first about their loved ones and who they were. And for us, that was a very important starting point. And it had been done previously in Hillsborough, it had been done in Ballymurphy. And the importance about that is for us, you've so many lawyers in this room. This was going to go on for months and months, if not a year. And we wanted to make the point that before we do anything, before we start, we all remember why we're there. We all remember that we're talking about real people who real brothers, sisters, mothers, daughters, fathers. We wanted that to be the center. We want the families to be the center of the process. And for me, I still remember on day one when the first pen portrait was read out, and many people didn't know what to expect. And the question came from the jury: "Are we allowed to clap?" Which we thought was a very, very important starting point, because it sent the message that these were very, very courageous families coming in to give their evidence in circumstances in which they was daunting for them. Some of these people have never done public speaking, but yet had to take a witness box to talk about the most difficult thing of all, the loss of their loved one in the Stardust fire. And after a year at hearing, the jury returned the verdict of unlawful killing, which was a seismic decision for these families, because the verdict recorded that the fire had not been started by arson, but indeed had started as an electrical fault in the hot press. And secondly, that there were a number of failings in the nightclub itself that ultimately the jury recorded in its findings, such as the doors being chained and locked, which for us was a seismic decision for these families in their campaign for truth and justice, because one, after 4 decades, the truth was told. There was no arson. it was a fire that started by an electrical fault in the hot press. Two, none of these victims were in any way at fault. The exact opposite, in fact, they were exonerated, and they were young people who went out for a night out and who never came home simply by virtue of no fault of their own, and that they, due to the mechanics of the nightclub itself, they had no chance by virtue of the various materials, the tiles on the walls that made the fire spread at rapid speed, the fact that some exits were blocked or obstructed, and it made it very, very difficult for anybody to escape. So those facts were very, very, very important for these families to establish. And when you talk about, you asked about the hooded men and the reaction, it's another day, I have to say, that will never, ever leave me. The day that verdict was read out, I'll never forget the courtroom. It was like a reaction I've never heard. Such a roar of happiness. And I always, when anybody asks me about the Stardust verdict, I always just say, I remember one thing vividly. When the verdict was read out, the whole room just erupted. And throughout all the noise, it was as if the noise just stopped. And I just heard one lady to the right of me say two words, "at last." And that was it. And that's the only two words I remember hearing amongst the sea of energy. It was absolutely incredible. It's incredible. It was just such a privilege to be involved. And anybody who's ever met the families will know exactly what I'm talking about, because they're just the most brilliant bunch of people who suffered enormously, absolutely enormously. But despite the hurt, despite the grief, they showed enormous energy and enormous warmth. They became friends. They were, as I often say, it was so humbling. Used to turn up on a Tuesday morning for court, and the families be more worried about how we were than how we were about them. They used to ask how things were. They were that attentive to us, that they used to ask people about birthdays and anniversaries. It was just incredible. And to this day, we still get cards to the office on anniversaries and birthdays, and it just really shows that, the bond you create with people. And um, again, when we, lawyers, and we talk about cases, that sometimes is missed. How lucky we are. We meet brilliant, brilliant people, and unfortunately, those brilliant, brilliant people have come to us probably at a very, very difficult time, and in the worst imaginable circumstances, as the Stardust makes clear, but yet become long time, lifelong friends.
You're sitting in your office in Belfast, and you have spoken about a real optimism, you feel quite optimistic about Northern Ireland at the moment. Your firm, Phoenix Law, operates on a deliberate kind of collective, non-hierarchical model. And a lot of your recent work has involved defending cultural and political expression. At the same time, groups like NECAP, which you've represented, seem to be creating shared cultural spaces for younger people that cut across older divisions. From your vantage point, do you think law and culture together are beginning to loosen the grip of inherited identities, even if political unity remains elusive?
I think there's no doubt that that's correct, and I think that the one thing, and we touched upon it earlier, that I think is very, very important is, you know the north, and the north continues to have very, very divided views on very, very, very important, and even on international issues. But the one thing that, in my view, is certainly on the rise and continues to be on the rise, which I think is important for the north, is the acknowledgement and the reflection of the rule of law and the importance of the courts. Because we have seen both sides take different actions to court, seeking to uphold their rights, whichever way they perceive them to be, but respecting the independence of the judiciary, and respecting that decisions will be made. And in my view, like, because we touched upon the rights based issues, and there's no doubt that the courts have had to step into the void on very, very, very important and very, very contentious rights based issues. But they've also had to step into the void, unfortunately, on kind of more deep seated cultural issues, which sometimes can be even harder to unpick. Because the reality is, as we know, obviously the law operates in a very, very elusive way, where it must be done whether it's in compliance with public or administrative law, or on a private law perspective. But the issue is, I think that there is a growing sense of optimism, because, in my view, and maybe I'm naive, but I genuinely believe that in the north, we are on the trajectory of something great. And what I mean by that is, whilst there are undoubtedly deep-seated difficulties that arise, and like one, you need to look at any example of the fact of that we continue to put flags up on lampposts of prescribed organisations. I don't understand why that continues to happen, but there are deep-seated issues that need to be resolved. But in many ways, I think we're on the trajectory of something great in that we are now in Belfast is, you look at the economic prospects. Belfast is now the second cyber capital of the UK. Second to London, we get more cyber investment than anybody else. Secondly, we look at the contentious issue of the Northern Ireland Protocol. We look at the economic prospects that could potentially bring through the access to both markets. And also we look at the rights-based issues that the Northern Ireland Protocol brings, which allows for um, citizens who reside here to get access to EU law rights. That in fact means that we now have greater rights protections than we ever had, and we don't need to look any further than we look at the Legacy Act, or we look at the more recent Rwanda planes, the illegal migration proposals of the British government, where the courts here said no, can't be done because it's incompatible with the Northern Ireland Protocol. So whilst I think we have still such a journey to travel, I think that certainly I have an optimistic view for the future. I think we have an optimistic view in that um, there continues to be great prospect for people here. Obviously, the issue of the border poll continues to be debated, and I think that these are issues where when we talk about the border poll, I think it's about the importance of freedom of expression because we need people to engage. I always say that when we talk about border polls and the prospects of the future for the North, I always said it's the border poll makes the freedom of expression more important than ever because when we look at that question, the reality is there are always people, in my view, who will vote never to go to join United Ireland, and there are people who will always vote to join a United Ireland, regardless of the debate. But the people in the middle are open to be convinced. They're the people who should be the people who will be ultimately the freedom of expression will matter most. So I think the freedom of expression will come under its biggest hurdle ever when we look at this debate, because this is the debate where people have to be free to debate the issues. We have to hear both sides, because I think that's where we will ultimately see rights-based protections informing the future. And I think that when we look at the politics, you look at the politics of the Northern Ireland Protocol, many people jumped to the negative, the connotations of the IRC border. But in reality, it was the gateway to a better future. And I think it's only now that we're realizing that. So I think that, sometimes people become, unfortunately, entrenched in their position through historic political relations. But when we look at it through what the future can bring, we look at it through very, very basic, legal principles, I think the future is very, very bright.
Can we look a little bit more broadly, and we'll take this as the last question, Darragh? You work across domestic and international human rights systems at a time when the rule of law is under real strain globally. From where you sit now, do you see the rule of law as something that's retreating, or do you think it's transforming? And if the latter, what gives you reason to remain optimistic? You spoke primarily about Northern Ireland, but if we look more broadly internationally.
I think that where we are now in the world is utterly terrifying. I think that the rule of law is under the greatest attack that I'll ever have seen. When we look at what's happening in America in particular, and it's utterly depressing. We look at what's happening across the sea, where we see the likes of Palestine Action being prescribed as an organisation. We see protesters being criminalised. We see people being prosecuted under the Terrorism Act. I think we're entering into the territory of something that is utterly unknown, certainly for people of my generation. And I think it's totally and utterly terrifying where we are. And I think that, in times like this, in times of challenge, I think it probably underscores the importance of rule of law more than ever. And I think it underscores the importance of trying to understand and respect the rule of law for what it brings to global stability. And I think that if we effectively disregard the rule of law, we will enter a very, very dangerous place, because then we're entering in a world where there is no rules. And I think that, we all have a job to do now. We all have a job to do in trying to ensure that the rule of law is respected domestically and internationally. And I think that, only when that consensus is reached will we actually ultimately see a society that can ultimately be somewhere where we all want, our children to grow up in. Because I think certainly at the minute the trajectory that we're on is one of, aggression, one of ultimate hostility, and one where the rules don't exist. and international norms as we know them will be unrecognizable. But whilst they are depressing sentiments, and we look at the continuing and horrendous ongoing genocide in Gaza, I think it is impossible not to be pessimistic. It is impossible not to be worried about the rule of law in a wider perspective. But equally, I think that it is as important than ever that we stand up to that challenge, we stand up to that aggression, and it's very, very simple for me. I think that we can all make a difference if we can stand up for the rule of law domestically, but there are also mechanisms which collectively we can make a difference, and hoping to bring a fortitude and a respect for the rule of law internationally. And it is, I have to say, unfortunately, probably the greatest challenge in my lifetime, and I hope the greatest challenge I'll ever see, as to where we now are. But I don't look at it in a pessimistic way, because I do think that whilst we don't see a solution equally as easy, we have seen at different instances where the international sphere on the legal prism can assist. We look at the very basic examples where the European Court of Human Rights is obviously found against Russia in respect to Ukraine. We've seen the ICC issuing warrants for international war criminals. We've seen the ICJ preliminary determination in respect of the Gaza situation. The reality is, the international rule of law continues to play a factor. Now, unfortunately, it's not a one size fits all, and it's certainly not an immediate solution to the fundamental problems that we have. But I think we need to continue banging those drums, because if we just disregard those international mechanisms, if we disregard the international protocols, then we enter into a territory where the rule of law no longer exists. We enter into a territory where there are no rules, and we simply can never let that happen. But I believe that equally, this is where we see the rule of law and politics becoming intertwined in a way maybe that we're somewhat used to in the north, but maybe less used to in other countries, where there are deep-seated political issues here. There are deep-seated issues about foreign relations. But people now, more than ever, understand and respect basic human rights. This system has become like an education for many people who ordinarily wouldn't have known what human rights are. And I think that this is where human rights becomes centerpiece on the agenda. It becomes centerpiece in local elections. It becomes centerpiece in national elections. And it becomes centerpiece in foreign relations. And that is where I think we see a major difference. We see a major difference in circumstances in which ordinary people will use their democratic vote to put pressure on to ensure that the international sphere, Ireland on the international sphere, for an example, will put pressure to try and see and justify and move on towards a society which is based upon the fundamental principle of human rights.
Darragh Mackin, thanks so much for your insights. It was really great to have you on the programme today.
Thank you, Evelyn. Thanks for having me.
And that was Darragh Mackin, a director and co-founder of Phoenix Law, the Belfast-based human rights firm. A quick update before we go. If you'd rather watch this interview, we're now also available on YouTube at Irish Rule of Law International. That's it for this episode. Thanks as always to our funders, Irish Aid, and to you, our listeners. We'll be back in June. Until then, take care.